Hello and welcome. This video, Probate in Utah, is the 7th in a series of 10 videos designed to educate Utah residents about estate planning. For a list of all of our videos, see below or return to our website. In this video, we will answer the following questions. What is probate? Why is probate generally to be avoided? How can one avoid probate in Utah? What is joint tenancy? And what are beneficiary designations? For more detailed information, you can visit our website at utahtrustsandestates.com. As described in video number 2 of this series, probate is generally something to be avoided. But what is probate? Probate is a court-supervised process by which a deceased person's creditors are paid, the decedent's property is distributed to the persons who are entitled to it, and the recipients receive clean title to the property. Historically, probate was a lengthy, inconvenient, and expensive process. The probate process would generally take at least a year from start to finish, and it was not uncommon for it to last several years. Frequent court hearings would be required, as court approval was needed before any significant action could be taken. And the many court filings resulted in large attorney fees, accountant fees, and fees of other professionals. Such a cumbersome probate process still exists in some states. As we will see, Utah has more streamlined probate procedures. Under a traditional probate system, a court hearing was required to appoint the executor for the estate. Once appointed, the executor was required to file an inventory of the estate assets with the court, to notify and pay the decedent's creditors, to liquidate estate assets, to distribute the estate funds to the beneficiaries, to provide an accounting to the beneficiaries, and to close the estate. Many, perhaps all of these steps, would require approval by a judge at a formal hearing. Thus, it was not uncommon for a probate to require half a dozen court hearings, each of which had to be scheduled weeks in advance, and each of which required the attendance of the estate's attorney. In addition, probate proceedings are a matter of public record. Both the terms of the will and an inventory of the estate assets, possibly including the value of the assets, would be open to public view. For these reasons, probate is almost always a good thing to try to avoid. As a general principle, there are 4 ways to avoid probate in Utah. Number 1, an asset that is held in the decedent's revocable trust, also sometimes known as a living trust, is not subject to probate. Revocable trusts are discussed in detail in videos 2, 3, 4, and 5 of this series. Number 2, an asset that is held in joint tenancy is not subject to probate. Number 3, an asset that has a valid beneficiary designation attached to it is not subject to probate. And number 4, if the only property that would otherwise be subject to probate has an aggregate value of $100,000 or less, and if none of such property is real estate, that property need not pass through probate. As described in video number 2 of this series, a revocable trust is generally the best method for avoiding probate. Some people with very simple estates are content to rely upon joint tenancy arrangements, beneficiary designations, and the rules governing intestate succession. However, even for very simple estates, one should consult with one's attorney before deciding to go that route. Joint tenancy and beneficiary designations are often inadequate solutions for the following reasons. At death, property held in joint tenancy automatically passes to the surviving joint tenant without passing through probate. Holding title in joint tenancy thus avoids probate on the death of the first joint tenant to die. Title passes to the surviving joint tenant by operation of law. But joint tenancy is usually not a good solution for several reasons. First, property held in joint tenancy may be subject to the creditors of either joint tenant. Thus, adding an intended beneficiary as your joint tenant may subject the property to that person's creditors during your lifetime. Second, while joint tenancy avoids probate on the death of the first joint tenant to die, we never know who will die first. If you add an intended beneficiary as a joint tenant and that person dies first, you're back where you started. And if you are mentally incapacitated when that happens, you will be unable to name another beneficiary. Third, holding an asset in joint tenancy avoids probate only for that asset, and it has the disadvantage of removing that asset from a larger integrated estate plan. If the composition of your assets changes before you die, or if the respective values of your assets change before you die, using a joint tenancy arrangement may result in a different allocation of value among your beneficiaries than you intended. Property that is subject to a valid beneficiary designation, such as in a retirement plan, the proceeds under a life insurance policy, or in some cases in a bank or brokerage account, automatically passes to the beneficiary designated upon the death of the owner, without passing through probate. But like joint tenancy, a beneficiary designation avoids probate only for that asset and does not fit conveniently into an integrated estate plan. Thus, one problem common to both joint tenancy arrangements and beneficiary designations is that if the composition of your assets changes before you die, or if the respective values of your assets change before you die, using a joint tenancy arrangement or a beneficiary designation may result in a different allocation of value among your beneficiaries than you intended. For example, suppose you decide to leave your house to your son and your brokerage account to your daughter, on the theory that the two assets are of roughly equal value. So you make your son a joint tenant on the house, and you designate your daughter as the beneficiary on the brokerage account. But then what happens if the value of the house doubles and the value of the brokerage account falls by 50%? Now your son will receive 4 times as much in value as your daughter. For all these reasons, the use of joint tenancy arrangements and beneficiary designations are less than optimal ways to avoid probate. However, in some cases, the use of beneficiary designations is advisable and perhaps even necessary. For life insurance policies, the use of beneficiary designations is often appropriate to minimize estate taxes. And for retirement plans, the use of a beneficiary designation is often appropriate in order to maximize income tax deferral opportunities for the beneficiaries. Indeed, a retirement plan cannot be transferred to a revocable trust. But for other assets that sometimes offer a beneficiary designation option, like bank accounts and brokerage accounts, designating a beneficiary may be problematic for the reasons I've already described. In Utah, no probate is needed if the value of all estate property that would otherwise be subject to probate is no greater than $100,000, and if none of such property is real estate. If these conditions are satisfied, a bank or brokerage firm is required to turn over the decedent's funds to the beneficiary of the estate upon receipt of an affidavit stating that the recipient is entitled to the funds. Utah has adopted the Uniform Probate Code with its greatly streamlined probate procedures. In Utah, the executor can be appointed by the court clerk without a hearing before a judge. Once appointed, the executor has the authority to administer the estate, to distribute the trust property, and to close the estate, all without court involvement. Of course, if an estate beneficiary objects to the executor's actions, the beneficiary can file objections with the court and obtain a hearing before a judge. But even with Utah's streamlined probate procedures, it is still a good idea to have a revocable trust in Utah. As discussed in video number 2 of this series, if you have become incapacitated, or if you move to another state before you die, or if you die owning out-of-state real property, or if certain actions need to be taken very soon after your death, or if you don't want your financial affairs made public, you or your family members may wish that you had a revocable trust. That concludes this video. I hope you have found it helpful. For more information on this topic, you can visit our website at utahtrustsandestates.com or call us at the number you see on your screen. If you would like to watch another video in this series, either click on the appropriate link below or return to our website. Thank you.